thank you very much for everybody joining us today. It's a very opportune moment, we think, to discuss the ISDA 2020 IBOR Fallbacks Protocol, because it has its implementation date on Monday, the 25th of January, coming up. And we imagine that almost everybody who's been signing up for this talk has some idea about the Fallbacks Protocol already. They've been involved in the IBOR transition work. And what we're looking to do is to delve into some more detail as to how the protocol works, the LIBOR cessation timing, our thoughts on who the adherents are, and they have been ratcheting up on ISDA's website by 500 to 1,000 a day over the last week or two, and who is not adhering to the protocol and why. What are the reasons for that? We'll look at how to deal with those out-of-scope counterparties, the documentation that is available from ISDA to do so, indeed how useful that is and how you need to tailor that. We're then going to look with structured products and CLOs, which will fall outside of the protocol, but we'll look at how you can be using the protocol to assist with those changes through incorporation by reference and bilateral agreements in incorporating or restating the protocol, how to deal with some other non-standard derivatives. And we are also going to look at the implications for loans and hedges, and finally spend a little bit of time on tough legacy contracts. What happens under the existing 2006 ISDA definitions if you have a counterparty who just refuses to engage, refuses to adhere to the protocol, refuses to enter into mediation agreements if there is not a legislative solution? So we'll work through a hypothetical example. So moving to my first slide, I have taken some screenshots here of the relevant parts of the protocol and a helpful document. But I thought it might be useful just to mention what the Fallbacks Protocol is part of, I'd almost say, an ISDA tradition that ISDA has used protocols for many years now. And the idea of protocols generally is market counterparties may have thousands of effective transactions, which for one reason or another, they may need to be updated en masse. Now, without the help of a protocol, each of those transactions has to be amended individually. Now, that could be done in one principal agreement between two counterparties, or it could be by having amendment agreements for every single transaction, but it would be a logistical headache and continuous reinventing of the wheel. So we've had various protocols over the years. We had a protocol to update the 1992 ISDA Master Agreement with terms from the 2002 ISDA Master Agreement. We had a very successful protocol to update credit derivative transactions, which had the 2003 or 2009 Big Bang credit derivatives provisions in them, and update those to the 2014 ISDA credit derivative provisions. But we've also had some very unsuccessful protocols. And one of these was the protocol that was made for variation margin. And it just wasn't the VM protocol just wasn't very popular in the market for reasons not to go into here. So for us as derivatives practitioners, when the Fallbacks Protocol came out, we've been looking at this again. Will there be a big market uptake of this document? Well, Chris is going to look at the numbers and who's adhering in a little more detail. But on 18th of January, when I went into the ISDA site, you'll see on the top right of my screen that 7,230 counterparties had adhered to the protocol. Now, from review, it seemed to be all the big players had adhered to this. And of course, there will be multiple entities from the same institution, affiliates and similar, who will have adhered. But it looks very much, and I won't steal Chris's slides and thoughts, but it looks like a large amount of the market has signed up to this. Now, how is the protocol structured? Well, the first part, it has two parts. It has a protocol main part, which covers how amendments are made and how adherence takes place. And then we have a supplement and an adherence letter. So the first part of the Fallbacks Protocol sets out which agreements are covered by the protocol. And we're going to look at that in more detail in the next slide. It also looks at which rates are updated, who can adhere to the protocol. We're not on that next slide yet. That's a very my assistant there is a little bit trigger happy changing the slides, and it looks at which rates are updated, who may adhere to the protocol, so principals and agents, and that's all set out in that main section. Now, the way that any changes are implemented into any affected transaction, again, we're going to look at that in a moment, is through having the supplement to the Fallbacks Protocol is in fact a supplement to the 2006 ISDA definitions. So if you look at my screenshot there of the supplement, you see it says supplement number 70 to the 2006 ISDA definitions. So you might ask, what are the other 69? Well, since 2006, all sorts of changes to when rates are calculated, interest periods, different effects on different currencies have been added as supplements to the 2006 ISDA definitions. And all of those supplements, if you enter into a new transaction tomorrow, which says the 2006 ISDA definitions apply, you wrap in all of these supplement numbers. So for new transactions after the implementation date that you enter into with the counterparty, you incorporate the 2006 ISDA definitions, you will get all 70 of these, including the fallbacks provisions, put into your new transaction. Now, there's a side project going on at the moment, and it's a big side project, and it's creating the 2021 ISDA definitions, and that will sweep up all of these 70 supplements plus some other major changes into a new set of definitions, and it's much required. It's 15 years since the last update of the definitions. There was the 2000 ISDA definitions before that. But the provision we're going to discuss about how you actually amend IBOR rates to new risk-free rates is contained in this supplement to the 2006 ISDA definitions. And how do counterparties access or implement these changes that are set out in the supplement for all of their existing covered transactions? Well, they sign an adherence letter, and that's set out as an exhibit to the Fallbacks Protocol. And by signing that protocol and either putting it into ISDA or you doing that through ISDA Create, any counterparty of yours that has done the same thing, you will make the changes that are set out in the 2006 ISDA definition of supplement here, supplement 70, to all of your existing transactions. Now, there's a fourth document, and I've highlighted it here. It's on the ISDA IBOR webpage. It's fantastic. It's the ISDA 2020 IBOR Fallbacks Protocol FAQs. And that's got everything in there, all the questions about nuances for print agents to sign up, how the whole protocol works. If you haven't seen it, thoroughly recommend doing so. On to the next slide, please. So running through that again here, execute the adherence letter. The protocol opened on 23rd of October, so it has quite a long period to execute adherence letters. It had an escrow period, but beforehand, very importantly, you cannot make, beyond the very minor elections that are in this adherence letter, you cannot make changes to the protocol in your adherence letter. So those have to be dealt with, any changes you do want to make with your counterparties. These have to be done separate amendment letters, and we'll come on to that later. It's as mentioned, you can see as we move across here, it brings in supplement number 70 to the 2006 ISDA definitions, where those are incorporated. In the future, the changes are automatic. The Big Bang implementation date, although this is 25th of January, there is no long stop on counterparties adhering to the protocol. So if they haven't done so, they still can do so. Now, often with ISDA protocols, it says there's a time limit in adhering to the protocol. After that, you can't do this. There's no cutoff, but ISDA has said they can implement a 30-day limit. And what it brings in, and we're going to look at this in more detail, is moving from IBORs to risk-free rates when certain pre-cessation events occur, amending legacy IBORs across those risk-free rates, and that's quite complicated. And we're going to look at that in our following slides. So on to my next slide, please. So this slide shows, as we said, what's covered by the protocol. Well, it covers 3 categories of documents. Protocol covered master agreements, which are ISDA master agreements, but also additional master agreements. That's going to come, we'll come on to that in a moment. Protocol credits, well, and one point to note is you might say, but you rarely have an interest rate in an ISDA master agreement. Why is this covered? Well, occasionally you do find some sort of IBOR rate set out in the schedule. And I'd probably say from the big projects that we've worked on, maybe it's a 1 in every 20 that we've looked at. But it does mean that you capture with the protocol any master agreements as amended by a schedule which have an interest rate. Credit support annex as well, or credit support documents of court. Now, quite often you have interest rates there, and they may be IBOR rates, which is great because those can be updated. But often, and we'll have a look at a moment, but rates such as Fed funds and not court, so those need to be bilaterally amended, but we'll come on to that in a moment. And of course, where are we going to see a lot of IBOR rates? We'll see them in confirmations. So protocol covered confirmations, and those are captured as well. Now on to my next slide. Now, one of the wonderful things about the Fallbacks Protocol is it doesn't just capture ISDA master agreements, it has a huge list. And if you go into the protocol, you'll see this of local law master agreements that are caught, so the Spanish CEMOF, the French FBF, various other ones. Also industry-specific master agreements, so JUMSLAs and JUMRAs for stock lending and repurchase agreements are captured, as are various foreign exchange agreements. So it's worth looking to see if any other agreements you have are also captured by the protocol. Now, one big flag to put in here, there is one key agreement which is not caught, and it's the German Rahmenvertrag. And that's because protocols do not work under German law. So one of our German partners, Patrick Scholl, getting a big push. So do make sure you mention that, because we're doing a huge amount of updating these for market participants, updating the German Rahmenvertrags, because these are not captured by the protocol. On to the next slide, please. Which rates are updated by the protocol, which are not? So I've got a list here of all these captured IBORs. So it's not just the LIBOR rate. You've also got ones such as TIBOR, the Tokyo Interbank offered rate. Euribor is caught as well. The bank bill swap rate, various rates here. I have a list in the slide of who the administrator is, which is the new alternative risk-free rate that's moving to. And of course, the big ones are that LIBOR is moving towards SONIA, so UK LIBOR, and USD LIBOR will move across to SOFR. But there are some rates which aren't captured. So the effective Fed funds rate and ESTA, which are used extensively as overnight rates and CSAs, are not captured by the protocol. However, because those rates have been updated for cleared transactions through a market solution, it's very common to need to update a credit support annex as well. Now, there is the documentation to do that, but it's worth noting that the Fed funds rate and ESTA are not captured as covered rates in the protocol. So on to next slide, please. The next area is called, well, we said which rates are updated and what rate are they updated to? Well, when will they be updated is something that's covered by the protocol. And this is in the protocol section, it's not in the supplement. And it's it's set out in the supplement, and this is what we define as index cessation events. So there where counterparties have adhered to the protocol, this change across to the new rate is going to take place when a rate administrator makes a public statement that announcing that it has ceased or will cease to permanently or indefinitely administer LIBOR. It could be where a regulator makes a public statement of the same. It could be for LIBOR only, so this doesn't cover TIBORs or some of those other rates we mentioned. The UK regulator, the FCA, makes a statement or publication of information that the LIBOR rate is or will become non-representative of the underlying market. That's what we call a pre-cessation trigger, because it means that the IBOR rate is still being published, but it's no longer a liquid rate. And then we have an index cessation effective date, the first date that IBOR is no longer provided. So these triggers are what moves across these transactions with IBOR rates across to the new risk-free rates. And if we could move on to the next slide, please. So one of the complications we have, and I mentioned there are various complications, are that the risk-free LIBOR is moving across to what we call risk-free rates, RFRs, or alternative reference rates. And certainly in the case of, although SONIA, the risk-free rate for sterling is a reformed established rate, SOFR, the most relevant for US dollars, is a newly created rate, which means there's various adjustments have to be made by the market. Now, an additional complication here is there's several complications. And one is that SOFR is a backward-looking overnight rate in contrast to its forward-looking LIBOR predecessor. And of course, these rates are, new rates are also risk-free rates, while the LIBOR predecessor contains an element of credit risk. And when we look at this difference between forward-looking and backward-looking rate, a backward-looking rate can only be made at the end of an interest period, whereas your LIBOR rate was made looking forwards at the beginning of an interest period. So what this supplement does is it builds in a mechanic as to how that backward-looking piece is made for the new rates. And this is called a look back with an observational shift. And that works by looking back to a weighted number of business days in an observation period for the interest period that's just passed, rather than looking at the entire entire interest period. And we've got a similar but nuanced approach for the sterling market. Now, we have to throw in another complexity, and that is credit spread adjustment. And that's because that's to take account these new risk-free rates did not have a credit element built into them. So how do we make an adjustment to cover that? And ISDA carried out extensive consultations with the market regarding the use of RFRs compounded over an applicable tenor. And it's done that by taking a 5-year historical median and looking at across the relevant IBOR to calculate a spread adjustment for the new risk-free rate. So moving on to my next slide, please. Just working through that, looking at that a little bit more detail. If you were to go into the 2006 definitions for Euribor, you would see in a confirmation, you'd have Euribor's Reuters rate that had been defined, and you would look and you'd see that there were no index cessation fallbacks that would be of use in the circumstances. And let's move over to the next slide. And before I just launch across to Chris, it's that reason I do recommend having. We're going to look at a little bit at the end when we look at what would happen if a counterparty refuses to engage with the process. But it is worth looking for each of the rates that are relevant to you. What were the existing fallbacks in the 2006 definitions? And as we just saw with Euribor, and as we'll look at our example at the end, there were no really useful fallbacks to deal with that. And that's fundamentally why we've needed this protocol to come in to build that bridge across for the change. So with that, I'm going to pass across to Chris Arnold.
Thank you very much, Ed. Good morning, good afternoon, everyone. I'm just going to pick up where Ed left off and just talk a little bit about the latest on the LIBOR discontinuation and how that will potentially impact parties' positions if they've signed up to the protocol and how the timeline is going to work. So way back in July 2017, which seems like an age away now, the FCA, which was the UK regulator, which regulates the submissions and production of all LIBORs, including US dollar LIBOR, announced that it wouldn't require the banks to submit to LIBOR after the end of this year, December 31st, 2021. And that's been really the target date of everyone's efforts for the past 3 years. And the regulators, the FCA and US regulators and others have been at pains to tell anyone that listens that LIBOR, that they can have no confidence that LIBOR will continue beyond that date, and that they should make preparations for that transition. Of course, that's sort of easier said than done, and we are very lucky in the derivatives world to have these wonderful protocols which potentially can provide market-wide solutions for updating legacy contracts. Of course, we don't have an equivalent in the cash markets, and so we have these concepts of these tough legacy contracts to deal with, and as we've gone through the last year or so and having to deal with the pandemic through all of this, it's obviously become quite clear to regulators that the risk of LIBOR disappearing altogether at the end of this year is perhaps too great to contemplate now. So there's been a bit of a shift, and that shift really culminated in November, where ICE Benchmark Administration, who's the administrator of US dollar LIBOR, effectively announced that, I say announced on this slide, effectively announced an intention to consult, and its proposals were that it would only cease publication of the liquid US dollar LIBOR rates of 1 week and 2-month duration at the end of this year, that it does not intend to cease publication of the other tenors, which comprise the vast amount of derivatives and cash products referencing LIBOR until 30th of June 2023, so another 2.5 years away. It had also announced previously that it would cease publication of certain other currency IBOR rates, so sterling, euro, Japanese yen, and Swiss francs, at the end of this year. So it still intends to cease publication, but of course, there are far fewer contracts in those rates than there are in the US dollar LIBOR, which is obviously the key reference rate that we're all concerned about here. I'd mentioned that is a consultation. That consultation is open for comment until Monday. I hope if you intended to comment on it, you've already done so, otherwise it's a day tomorrow. But even though that is intended to be a consultation, it is viewed, that consultation is viewed largely as a procedural requirement, and it is expected to be the sort of final proposal, which should come in a statement probably next month, that this will be the IBA's position. We just move to the next slide. And the IBA hasn't obviously done this in the vacuum. It's done this in consultation with relevant regulators, and that was obvious at the time of the announcement, because both the FCA and all of the US regulators, Fed and OCC and others, issued coordinated statements at the time, basically saying, effectively, now is not the time to sort of slow up your work on transition. Still, all the banks are encouraged to cease new contracts as soon as practical. So don't wait until December 31st to cease as soon as practical, which I think most banks were doing anyway. And the contracts, new contracts after that date, do create safety and soundness risks for banks. I think that's partly because of the general concerns around LIBOR, but also as liquidity shifts to the new risk-free rates, then the LIBOR rates are going to have, the LIBOR-based products are going to have less liquidity. And the key point here, I think, to take away from this is that cessation date, that new cessation date, it's very much intended to allow for dealing with those legacy contracts. We'll look a little bit more at that in the rest of this presentation. But the real driver for this change of heart by the regulators is that there are still considerable numbers of contracts, particularly in the cash markets, that aren't maturing this year or anytime soon, and for which a cessation of LIBOR at the end of this year would cause considerable disruption. And of course, as always, the regulators encouraging the banks to use the extra time wisely and continue their transition plans unabated. And there's a sort of quote at the end that the Erwin Schooling Latcher of the FCA said shortly afterwards, that basically that it does not give market participants a reason to not adhere to the ISDA IBOR Fallbacks Protocol or otherwise defer transition in relation to US dollar LIBOR. So I think it's important that that message gets through, that this reprieve is not intended to prevent people or dissuade people from adhering to the protocol now. They're very much encouraged to do so, but it is a safeguard for those cash products. So just the next slide, just looking at the way in which these announcements, if implemented, would affect the obligations under the protocol. So shortly after the announcement was made, is to clarify that particular announcement of the intention to consult would not constitute itself an index cessation event for the ISDA protocol and the supplement, nor would it comprise a spread adjustment fixing date for the Bloomberg rulebook. The certainty criteria, it being only an intention to consult. However, if there is a final announcement as expected next month, that would trigger a spread adjustment fixing date for all of the US dollar LIBOR tenors, because effectively that announcement would extend to all of the tenors, notwithstanding the fact that the 2 week and tenor is going to be ceased at the end of this year, at the 1 week and 2 month tenor rather. So in terms of where that leaves your swap contracts, if you adhere to the protocol or your new contracts after next Monday that implement the definition supplement, to the end of this year, no change is likely to happen to those contracts. You'll still be referencing the LIBOR-based rates, and you'll go on calculating based on those published rates. Between the end of this year and June 30th, 2023, there'll be effectively a bifurcation of treatment between the 1 week and 2 month LIBORs and all the other tenors of LIBOR. And even though the 1 week and 2 month LIBORs will cease publication, that won't take us into a SOFR-based rate as a fallback. What it will effectively do is mean that we will be applying linear interpolation under the ISDA definitions between the published rates that are the next shortest and next longest of those rates. So for the 2 month LIBOR, we will switch to looking at interpolation of 1 month LIBOR and 3 month LIBOR. So that will be, I think, it's very familiar to swaps practitioners, the way we apply linear interpolation. And then when we get to June 30th, 2023, and all of the LIBOR tenors cease publication, then at that point we fall back to the compounded SOFR rate plus the relevant spread adjustment that was fixed this year, potentially as early as next month when that announcement comes. So that's the expectation of the ISDA in the market as to how this will play out, assuming that the IBA proposals are confirmed. And in fact, after much discussion over the last year or so about this concept of pre-cessation triggers, it seems unlikely that we're going to have pre-cessation triggers, certainly for US dollar LIBOR, although those concepts are still possible for other currency. So the timeline is likely to play out. Of course, as Ed said, this relies on people adhering to the protocol. And so moving to the next slide, just looking at that adherence process is going. As Ed said, the numbers moving rapidly on this slide. We had 7,800 adherents as of January 19th. I just checked before the presentation, we're up to 9,384. So a good 1,500 or so have adhered in the last couple of days or so. And that includes sort of all the major trading entities of the global dealers. So they mostly adhered in that escrow period before the protocol was actually launched, just to give comfort to clients that they would all be adhering and that they would be, the contracts would be treated the same way across all of the dealers. Includes lots of national and regional banks, asset managers, pension schemes, funds, and many, many corporates that use derivatives in their hedging activities. Just to say, when the protocol is open to everyone, to all entities to adhere to, and it's entirely voluntary to adhere. I'm not aware of any, although regulatory statements have been very positive with respect to the protocol. I'm not aware of any regulator mandating it for any particular counterparty. Of course, there are, as Ed mentioned, other ways in which one can build these the fallbacks into one's contract on a bilateral basis. The identity of the adherence is all published on the ISDA website, so you can check quite quickly whether your counterparty has adhered, and there's a sort of search function available there. And entities can adhere individually or as agents on behalf of clients. So in many cases, we'll have the asset managers and the like adhering on behalf of multiple funds, so that adherent number is probably underestimating the true number of actual entity adherents. So moving on to the next slide, just touching a little bit on the reasons why people may not adhere, other than sort of a lack of information or understanding of how the protocol works. I think the key point here, particularly for entities that are using derivatives to hedge cash products, is: are we confident that the transitions that will apply under our derivatives will happen at the same time on the same basis as those cash products? So, do we feel that our LIBOR rate in our loan is going to transition to both at the same time and to the same fallback as on our derivative? And if we're not confident of that, then there's obviously a risk that if we adhere to the protocol, then we create a basis risk for both the duration of the fallback not occurring, and also whatever rate we fall back to. I mean, hopefully that is not a major concern of many people, and obviously there's been a big push in the cash markets to ensure that fallbacks do follow the derivatives market here. The derivatives market is a sort of bit of a first mover advantage, and everyone's waiting to see what happens with the derivatives before switching to cash products. But it is a key concern, and as I said, we're not amending cash products by protocol, and that would obviously be a discussion that borrowers have to have with their lenders. Moving on, is the protocol effective to amend my contracts? Are the agreements covered? We'll look in a second at the agreements that are covered, as mentioned. So, are we confident that the protocol is going to amend the things that we need it to amend, and perhaps importantly, not amend the things that we don't want to amend? So that's a sort of diligent exercise for my participants. Will I need to bilaterally exclude any contracts or transactions? What will be the economic impact of my portfolio of the spread adjustment? So I think it's clear that there will be some kind of value transfer involved in a shift from LIBOR to SOFR or LIBORs to other risk-free rates. That is intended, obviously, to be as neutral as possible, but just the way that these rates work and the spread adjustment is inevitable. I think that there will be some deviation between what SOFR is and what LIBOR would have been. That may be something that people are sort of quite happily riding, but there may be situations where you have particular products, some non-linear products, particularly where you might see an evident value transfer there for you across your portfolio, which you may want to consider carefully before adhering. For agents, is it comfortable adhering on behalf of all of them which you represent? Will the fallbacks trigger a life cycle event? I think the answer is hopefully not, and I think there have been some statements so far from regulators providing some comfort on that. And what I mean by that essentially is that where we have legacy derivatives that were entered into prior to margining or clearing mandates coming into effect, will the amendment of those contracts, either by means of entering the protocol now or more importantly, when the actual fallback rates trigger, could that constitute a life cycle event which would bring those contracts within the scope of margining and clearing? Hopefully that won't be the case, or a reason for people not to adhere. And finally, just if you have any contracts which require third-party consent, such as rating agency confirmations or the like, to amend your derivatives, your hedges, you need to get those consents, you need to make notifications, because you are, by adhering to the protocol, assuming your counterparty is also adhered, you are effectively amending those contracts. So just the final slide on this, really just reiterating what Ed had said. Just move to the next slide. The protocol will cover, all protocol cover master agreements, which, as Ed mentioned, covers a whole raft of different agreements, over around 70 additional master agreements, including local law master agreements, repo agreements, security lending agreements. And of course, sort of similar credit support documents. They must reference one of the relevant IBORs in the protocol. And I think key to this, it must incorporate one of the ISDA definitions from the definitions booklet. So either the contract incorporates in whole by reference one of the definitions booklets, or it lifts one of those definitions from the booklets. Where the definitions have been lifted, of course, it's important to ensure that the definition was actually identical to the ISDA definition. Otherwise, there's a risk that relationship wouldn't be covered by the protocol. Just the final point I'm going to say, we at Mayer Brown were happy to help ISDA in terms of its legal due diligence on the enforceability of the protocol. And we issued opinions on the New York law and English law on the enforceability of the protocol for all of the major ISDA master agreements and ISDA documentation, so that ISDA has conducted its legal due diligence process to provide comfort to its members. There has been no legal due diligence with respect to the non-ISDA master agreements. ISDA hasn't conducted that. So to the extent you have a master agreement governed by a different governing or local law master agreement, you may want to get comfortable yourself that the protocol would serve to effectively amend that agreement for these purposes. With that, I'll turn back to Ed. I think he's going to talk to us more about how we deal with out of scope agreements.
Well, Chris, thank you very much. And it's very nice to see some questions coming up in the chat box as well. There's 2 questions. One of them was not addressed to the wider group, and the other one was addressed more broadly. So just linking one, I'll deal with the first question and then ask Chris in his next piece perhaps to cover the second. But somebody had asked if their firm is not active in the interest rate swap market, but instead trades FX derivatives and equity derivatives, is the protocol necessary? Well, the answer there is only if you have IBOR rates which need to be updated. Now, almost all of your FX derivatives transactions, I'm sure, might not have an IBOR rate to be updated, but it may well be if there's some sort of funding leg in there. So you do, I would check through those. And the same with your equity derivatives transaction. If there was a funding leg in a total return swap and it had an IBOR rate, then you would need to consider signing up to the protocol. This also links into a point where Chris was talking about the people who'd adhered and hadn't adhered. And there's when Chris and I were looking at these slides at the end of last week, I thought, well, we should call up some of our clients who on the buy side, and check whether they're adhering, because you can see on the ISDA list who's adhered and who hasn't. And although some have said, no, we're not adhering because actually we have bespoke transactions, we just need to deal with these outside the protocol, there were some who said, you know, protocol, what protocol? And just you may well find that some of your counterparts just have not been aware that these changes are coming up. So it's a suggestion that if you have counterparties who haven't signed up, who do feel you should consider whether to let them know about the changes, ask if they're going to adhere, ask what their plans are. So moving on to my next slide. Now, there are many reasons why the protocol isn't suitable. Now that, and so a counterparty can adhere to the ISDA protocol and it would be suitable for 95% of their transactions, but there could be various ones that are not suitable. Now, you can't amend the protocol directly in the adherence letter. So if you've adhered and you have agreements that you do not want to be included, help is at hand from a series of ISDA templates. I do recommend looking at the ISDA site to see these. And there is template forms of amendments. Now, reasons why the protocol might be not be suitable, well, it could be that a counterparty has a real estate finance hedge that's hedging a loan, or indeed any hedge of a loan. So you want to amend the loan and the hedge at the same time. Indeed, there may be an event of default not to amend the loan without an agent's consent, and so one wouldn't want to inadvertently trigger an event of default through adhering to the protocol. So for those agreements that's not suitable or a counterparty does not want to adhere to the protocol, there are template forms of amendment, and there are 4 of these in terms of. And let's take the first one. There's a short form of agreement, and what this does is it incorporates the protocol by reference, and the parties can then make the changes that they want to do. Now there's one version for entering into this as a principal and one version for entering into it as an agent. The next form is a long form, and the only difference here is that the protocol is slapped on the back as an annex, and then the same thing happens. So you get all the advantages of the protocol through entering into an amendment agreement, but you can make the tweaks that you want to. So looking at the loan point, you could say everybody's signing up to this agreement, so agent, the agent and the hedge counterparty and the borrower, and here's when we're going to make the amendments, and we're going to make some changes to align this with the underlying loan. Now, on to my next slide, please. That's just a little bit more information set out for everybody here, and we've included some examples as well as to why you'd like to use the different versions. So on to my next slide again, please. That's the short form agreement. And the same holds for the long form agreement. Another example of counterparties that might like to do this, private wealth clients who have a limited number of transactions, don't really want to get into exactly how this whole protocol thing works, or indeed don't want to reveal to the world that they are entering into derivatives transactions, may wish to use this. On to my next slide, please. There's also some very helpful language on the ISDA site of how that you can template forms of language which you can put in to your short form or long form agreements. Here's an example here, disapplication of the pre-cessation trigger. So if you don't want to have these pre-cessation triggers, or want them to, for example, because something's linked to a loan, you want to do it in your own time, here's some language to put in. Next slide, please. There's 5 clauses as well that are set out in one document, which provides things such as language to exclude existing documents from the scope of the protocol. So that might be a TRS that you have in place. You want to include all of your interest rate swaps with the counterparty, except for that particular equity derivative that has a financing leg. And here's some language to do that. And on to the next slide. We've got various other options for doing that and how that's done. So what we've done, without going into these in each detail, but really for the materials for our talk, we've put 5 options of how these exclusions can be done. And as I say, the template wording for this is all on ISDA site. So we move to my next slide, please, which has 3 and 4 there. Again, when these materials are circulated, these are helpful things to see, and we've put in some examples here as to how those work in practice. And onto my next slide, please. And our final option, option 5, that's included in that template document, is how you can put all these together using different combinations. Now, what I would say is these are helpful options here, but they don't cover all the nuances that you could face. You do need to review your whole portfolio, see what should be in the going on the protocol, but just as important to look at what shouldn't be going under the protocol and what you should separately and bilaterally mediate using these bilateral forms provided by ISDA as a base, incorporating the protocol by reference, and then making the documents you'd exclude and nuancing the ones you wish to include. So my next slide, please. I say there's further language there, as I just mentioned, that you can include additional documents to fall within the protocol. So these could be things such as in securities lending. You could build in securities lending authorization agreements. You could build in other transactions that have IBORs within them, which are not covered by the protocol. So again, that language is there and available. And next slide, please. Finally, last couple of points I have to make. I mentioned that Fed funds and ISDA are not covered by the protocol. However, there is a new set of collateral agreement interest rate definitions which apply fallbacks for these overnight rates, and you can incorporate those by reference into new CSAs. And onto my next slide, we also have coming up, you'll see at the bottom it said the 2020 is the interest rate definitions. Well, it couldn't be finished in 2020, so it's now becoming the 2021 interest rate definitions. They're a root and branch update. They'll include everything that's in those, all of those 70 supplements, including the fallback protocols, but other things as well. And we often find with these new updates that it takes a while for these new definitional booklets to get traction. And then I think my last slide, because as mentioned, ISDA and Fed fund rates are not updated by the protocol, there is a form of ISDA and SOFR amendment agreements that you can put in bilaterally in place to amend CSAs separately as well, which has proved to be quite much larger exercise. So I think that slide takes back to Chris. Oh, actually, I do have one more slide. Sorry, I will just cover this quickly. Here's an example, an IBOR Fallbacks product table. Again, it's on the ISDA site, and it sets out for all the different nuances of derivatives, be it cross-currency swaps, which have an interest rate set into them, swaps with periods that differ from IBOR tenor. It sets out what happens under the protocol and puts in additional fallbacks that you might wish to amend and put into a bilateral amendment agreement. I have a few more of those set out on the next slide, but I thoroughly recommend going and having a look at this fallback product table to see which derivative transactions do you have which you should amend separately and bilaterally in addition to entering into the protocol. Next slide, and that's Chris, it's back to you.
Thanks, Ed. I mean, that just last slide picks up neatly on one of the questions we had on the interactive chat, and that was a question around where some of the specifics of how the SOFR rate will apply when the transition from the LIBOR rates occur under the terms of the protocol and the ISDA supplement. And that I just referred to the Bloomberg rulebook. So at the same time as ISDA published the protocol, it jointly with Bloomberg published a rulebook, which is a sort of very helpful document in terms of setting out really the kind of agreed conventions for how SOFR LIBOR rates were going to transition to SOFR rates, including how compounding will work, observation periods, etc. So that's the place to look to really find some of the meat that's put on the bones of those fallbacks in the ISDA supplement. So I'll refer you to that. So just spending the next sort of last few minutes we have just looking at some of the sort of tougher issues really that the protocol won't directly address and still should be in front of people's minds who work in this space, and looking specifically at products that are related to derivatives products. Lots of funded structured products, sort of structured notes type products, obviously are effectively packaged derivatives, and they won't of themselves be amended by the protocol because they're obviously not between adhering parties. They are held by note holders, and their conditions can only be amended by consent of note holders or trustees or whatever. So there is the potential for a mismatch of approach in the derivatives underlying those products and those products themselves. Now, hopefully, in many cases, that will be resolved by the extension of the periods for LIBOR's publication. So some of more of those products will run off in that time. But there is potential that it won't, and there is therefore a challenge for some structured products to determine whether those products need to be redeemed or reissued or amended, and so on. And it may be particularly acute in certain structured products that are not just floating rate notes, but are have kind of complex payments related to LIBOR, like the range accrual type notes, where you're looking at sort of daily observation of LIBOR rates. So those products might not fit well with amended hedges that now refer to SOFR. So, having largely solved the derivative problem for many market participants, there still will be a bit of a structured notes headache, I think, to contend with. Those issuing products now should be reflecting that already, but those legacy contracts will still cause a bit of a headache. So just moving on to CLOs as well, again, not sort of directly related to derivatives, but I think the CLO market is another one that potentially could have been problematic if the LIBOR rates had not, or LIBOR rates hadn't ceased at the end of this year. There's an estimate that around 10 to 20% of US CLOs at least do not contain fallback provisions. So the extension should help them, and this again relates to another question that was raised in the chat, and that's the status of the legislative initiatives to try and deal with tough legacy contracts. They're certainly a work in progress. There seem to be initiatives in New York, federally, and potentially in the UK as well, to provide legislative solutions to contracts that simply can't be amended or not being amended by the time of the cessation. I think those will continue. Hopefully there won't be that much to falling in that category by mid-2023, but it seems there still seems to be legislative appetite for addressing those problems. So there'll be more to look out for in there, I think. And then just a couple of other thoughts on the next slide. Non-standard derivatives. Again, sometimes in hedging swaps, we see sort of bespoke LIBOR definitions, which are lifted or cross-refer to relevant securitizations or loan documents that they are hedging. And so just to be mindful of the fact that if you're not using an ISDA definition, or you've amended your ISDA definition, then protocol may not pick up or would not pick up that particular contract. So that might require bilateral amendment if it's desirable to amend. And that was all I was just to hand it back to you, Edwin.
Thank you very much, Chris. Well, last couple of slides so we can finish on time. If this really just try have the loud alarm bell ringing, that if you adhere to the protocol and you have loans which are hedged with hedges linked to those loans, one really must take extra care over those, because amending those hedges could potentially cause some form of default on the loan, because so often, and it is the norm, that an agent needs to consent for any changes that are made to the hedge documentation. So a word of warning to borrowers, but also to the counterparties and financial institutions, which are counterparties as well. That's a potential problem. Now, once you do get round, and you do need to do these ones bilaterally using these bilateral agreements, there are the issues of coordinating the lender group, timing, looking, should the swap follow the loan or the loan follow the swap. In the US, the swap is, I think the market norm is the swap to follow the loan. It's less certain in the London market, and we've heard divergent rules. So just as you were looking at the CLOs, the structured products, extra care is taken with any hedging loans. And my final slide, it's a question that keeps coming up. What happens when you have a really awkward counterparty and they refuse to sign up to the protocol, and even worse, they refuse to mediate the transaction? Well, the answer is here, and we've got a little flow chart of what happens. And the answer is, and I put an example for those of you who've read the books I've written on credit derivatives and equity derivatives and others. I love using hypothetical examples of financial institutions. And my example here was a Cadiz bank. It had entered into a swap with Jerez Corp, who just refused to engage. Now, my example, Cadiz bank would, as the calculation agent, effectively ends up having to run its own dealer pool. So it has to go out into the London market, has to try and get these rates, offered rates itself. And if it can't get those rates, it needs to go across, and let's say our example was a USD LIBOR, it needs to go across the Atlantic, and it needs to ask the New York banks how much they would, what their rates would be to offer loans to European banks. And that would need to be done on each quarter, which would be a terrific pain, which is why we have these legislative solutions that are being considered to deal with this that Chris mentioned, and we don't have anything concrete for those. But it's a useful slide for working out the what if, and of course the calculation agent's open to lots of potential litigation from its awkward counterparty if it gets accused of not calculating a proper rate. So this is still a live one. There is a good chance this could get resolved through legislation, but that is uncertain.